Hi there, thank you for coming to today's video on my YouTube channel. What am I going to talk about? I'm going to talk about you. Now, I've already spoken about lawyers before, right? But today I'm going to talk about what it takes to be a good bankruptcy client. So, first, disclaimer, right? You know how lawyers are. I should put a little disclaimer sign coming up here right now. Don't get offended. Everything that I'm saying is for the benefit of you and is to establish a better attorney-client relationship. All right, so I'm going to start off with the basics. Seems simple enough. But just be honest. Be honest with your lawyer. There are so many things we could have avoided. I could have avoided if a client just told me. And I actually give my clients a speech on, I need to know everything. All right. When you go to the doctor and you're complaining and you have all these pains, and the doctor says, so you have any pains? And you're like this. He goes, you have a pain in your right shoulder? No, I'm good. I'm good. I don't have nothing. Yes, you do. Your doctor needs to know what that pain is. Your accountant needs to know if you've done anything. Your dentist needs to know whatever they ask you. And your lawyer and your bankruptcy lawyer, I don't care what lawyer, has to know too. You have to be honest. We don't like surprises. You want to show up to my office and give me keys to a new car? I would love that surprise. Okay. You want to show up and leave a suitcase full of cash? I'd love that surprise too, and so would every other lawyer. But the surprises we don't like is going to court and surprise, we don't like that at all. Be honest. You have no idea if we're ahead of the problem, how we can correct it, fix it, take the right approach, strategy, and avoid issues altogether. Okay. The next thing we need to know about is communication. Now, what this means is, and I have to be honest here, you don't need to call your lawyer every single day, 10 times a day. The reality is, unless there's an emergency, and we have all the documents, then sure, reach out to a lawyer. Hey, you have all the documents. What's the status? Make sure, you didn't get lost in the shuffle. But, and communications, also what type of communications? Text messaging, okay, but I think it should be something simple. Call me. Did you get the documents? People sometimes put a whole book inside a whole encyclopedia set. The younger generation are now looking up what's an encyclopedia. It's like Google in books. I don't know how to explain it. Look it up, Britannica. So you shouldn't write an entire encyclopedia set for your lawyer in a text messages. It's going to lead to confusion and miscommunication. Complicated, go ahead and put it in an email. And even then, if necessary, make an appointment with the lawyer or the paralegal to make sure these things are set up. Now, on behalf of the lawyer, I can tell you it's very difficult to speak to all. I've had hundreds of clients at the same time. Can't speak to all of them every day or every other day. And the reality is, a lot of times it's not necessary. And the basic is, if I haven't gotten all the documents, and even if I have all the documents, but you still haven't paid the balance of your attorney's fees and court costs, then there's nothing to talk about because I can't move forward until I receive that. So keep in mind, a lot of times clients say, this case is taking too long. It's been 8 months. And it's like, I haven't gotten paid yet. Could take 8 years if I haven't gotten paid. You need to pay, and we need to go through the whole process to make sure that we can move forward. So keep that in mind. Communication is important, but we got to understand we got to draw the line somewhere. That's just basically I could tell you is common sense. All right. Now, documents. Oh boy. Every lawyer I think I've spoken to says I get the grocery bag with about 50 statements in there. Sometimes they're open, sometimes they're not. We don't need 50 statements of the same credit card. Just give us the last one. Okay. And the fact that it's inside an envelope, it's stuffed, we have to open up the envelope, unfold it, and say, oh, I already have this bank account or credit card statement. We really don't need that. I know clients do that. I've gone to seminars, and the first time I heard that, I was like, oh my God, he's talking about my clients. So apparently that lawyer conducting the seminar and everyone else in the room had been in the same situation. So what are the odds of that? The odds are it seems that clients do that on a regular basis. Now, most of the information we will get from your, this is the way I like to do it. Most of the information we get will be from your credit report. I'll get all 3 credit reports, TransUnion, Experian, and Equifax. But I also want your statements in case one of those credit card agencies make a mistake. Nothing is perfect. So I check and I say, oh, okay, look, here's American Express, account number 1234. It matches that one. We're done. But just don't bring in 70 statements from the last 10 years full of coffee stains or whatever else you can think of, and throw it in a shocking bag and say, "Here you go, lawyer." I mean, I don't need none of us need a fancy book and folder and everything organized, although I've gotten that too. But just be reasonable, just keep it, again, common sense will do. Just think of, how inconvenient it is for a lawyer or someone to sit there and just start ripping apart every envelope, the time that takes, and then realize that you're getting multiple statements, February, March, April, May. We don't need that. Just give us, May, whatever month we're in, the last statement, or maybe the last 2 or 3 statements will be good enough. Always, if there's a question, the paralegal, the lawyer will ask you. Now, since we're talking about communication, this is important. Life was good. I wasn't complaining about anything about 5 or 6 weeks ago. And then came COVID. And all of a sudden, I'm 2 weeks. I mean, I got it bad. I had 103 fever at some point. I went from COVID to, I have a dry cough, which I still do. Sometimes when I start talking in the morning, giving my seminars to my students, I just start coughing endlessly. If I say coughing, I start thinking about coughing. I'm already thinking about coughing. But I went from COVID to the end of COVID, maybe 3 or 4 days, and then boom comes Hurricane Helene. Now there's no power for 13 days. Things change. If my home was affected or my business was affected, I have to reach out to clients and say, "I'm sorry, man, I have no electricity. Let me get through this and we'll figure it out." I have to tell you that. I should tell you that, right? You have every right to know what's going on with your case. But at the same time, you need to tell us if things change. Your car was repoed, we need to know. People are like, "Why? Just it's more debt and I got rid of it." No, because if you're making a car payment, let's say $300 a month, and now that car payment is gone, you have $300 more left over per month. We need to figure out a way to get around that. So keep that in mind. If you bought a car, we need to know. If you're now got a promotion at work and you're making more money, that's going to affect the income and expenses and the means test. All that information we have to know. Don't let us know the day before filing, "Oh, by the way, my bank statements, I already got a new job, everything, and I'm making 10,000 more." We need to know that way in advance. So keep that in mind. Now, here's a sensitive subject, right? How can I phrase this? The Google lawyer. There's the Google doctor, the Google dentist, the Google everything. All of us in this profession know we get that, and I understand. You look for information. Some information online can easily answer your question, right? When can I refile for bankruptcy after I had it in whatever year? The answer is after 8 years, you can refile again. That's a simple one. But the problem is when people start getting into details, and a blog is written or something, and they just apply it to themselves. And unfortunately, that's not the way it works. Once you start extrapolating, meaning getting this piece and applying it to everything, you're going to misinterpret, misapply the law every single time. I have no other way of saying it. Law school is 3 years of reading cases, learning the law when you sit down to take the bar exam, passing the bar exam, which, by the way, is not like everybody passes. In California, I think that recently last year was like 65%, or maybe this past year, maybe in June when they took it. Florida was about 80%. So people fail. And this is after years of educating ourselves and preparing for the bar exam. And then once you've done all that, now you got to learn to be a lawyer, because law school doesn't prepare you to be a lawyer. It prepares you to be a law student. And unfortunately, being a law student has nothing to do with being a lawyer. So the problem is people extrapolate, just apply it to everything. And so that comes here. Let me see if I can do a good arrow. I'm not using my pen. That's not so bad, right? Little messed up there at the end. Dictum. There's a case we've all heard. You can't yell fire in a crowded movie theater, meaning not everything is protected under the First Amendment. Well, people have gotten that and run with that. And you even see lawyers on credible media saying, "Well, you can't yell fire in a crowded movie theater." First place, a crowded movie theater is a private establishment. And the First Amendment applies to the government. So we're already talking apples and oranges. 2, why can't I yell fire in a crowded movie theater? What if I tell everybody there, "I'm about to yell fire, no one react"? Did I do something wrong? No. Is that protected under the First Amendment? First, again, I'm in a private establishment. What if I'm filming a movie? Or what if I still stand up and yell that and everyone says, "Here's the crazy guy, just keep watching the movie"? So That's not the law. The law is you cannot yell fire in a crowded movie theater. That is dictum. That was the judge explaining, basically giving an example, trying to elaborate on a point. But yet everybody has run with dictum, opinion, comparisons, and said that's the law. It's not the law. When I was in law school, you had the cases were 20, 30, 40 pages. It was insane. You get those 40 pages, you're like, oh my God, we have to read 2 cases, but there are 60 pages today that I'm reading. And nowadays it's highly condensed. I mean, when I was teaching in law school, maybe 3, 4, 5 pages. I mean, some cases were 8 pages, and I thought, I was like, 8 pages, because I was now used to this really condensed version, which just basically get down to the nitty gritty. But again, this is, people run with it. I've seen people say the judge denied all my evidence. The judge is biased. Did you lay a foundation? No. What does that mean? Did you properly apply the rules of evidence? No. I just told the judge I had the evidence. It's not the way it works. You're going to be treated in court the same way a lawyer is going to be treated in court. And so the answer is evidence, rules of evidence, that was 4 months. Civil rules and procedure, that was another 4 months. 8 months just dealing with procedure and evidence. And even then, you don't know anything about it. When you take the bar exam, it's until you're in practice that you realize, oh, wait a minute, or maybe you take a trial advocacy class. But that's the problem. I see people get a little bit of information online and just run with it all the way and say, that applies to me, and it does not. You see people constantly believe that they're going to remove their second mortgage with a Chapter 7 because they've read, oh, you could remove a lien, you could remove a mortgage with bankruptcy. They didn't realize there's a difference between Chapter 7 and Chapter 13. They filed Chapter 7 on their own, and then they're getting foreclosed on a few years later and don't know why. So you have to understand, be careful with the information that's out there. The law is very specific. I've taught law school. I can tell you the difference in some cases is the most minute thing, and even law students don't pick up on it. And law students have been doing this already for 3 or 4 years. You might be reading about a lawyer's blog in Boise, Idaho, and you're living in Miami. How they do things in Miami are going to be different than how they do things in Boise, Idaho. So you have to be careful with that. Don't run with all that information. Here's a blog that's going to be a separate blog altogether, but I'm fascinated by these groups of people that call themselves sovereign citizens who have this interpretation of the law that, again, they get a little bit of information, misinformation, and they run with it. And so what happens? Well, one thing is they say, well, under the UCC, Uniform Commercial Code, if you put on the bottom of the check on the memo line, last payment, and the mortgage company cashes the check, that's it. That changed, I guess, apparently all that little thing changed the entire modification of the mortgage and the promissory note, and they don't have to pay the mortgage anymore. And then they get foreclosed on, and they're asking me, how can they foreclose? I did that, and I said, that's no rule. Would you come up with that? Well, the UCC, and they throw these random sections of the UCC. Let's start off with the basics. The Uniform Commercial Code is not even law. It is more of a suggestion. There's that dry cough. It's a suggestion in the sense that, especially now, we're glad they did this so many decades ago. The law in Colorado is going to be different than Texas, Florida, Georgia, South Carolina, etc. Right? So how do we deal with all these different people doing business and everything else? How do we, try to make things uniform? A bunch of experts, contracts experts, experts in business and everything else said we're going to create the Uniform Commercial Code, and the states can adopt it if they wish. The states have. They might modify it the way that they want to, but it's not a law. Again, it's more of a suggestion for other states to follow. And we've done that consistently in other areas of law, like with divorce. That's why when one state says, this is what we're going to do now with this, the parenting plan. Parenting plans didn't exist when I started practicing law. Now every state has parenting plans. But again, it's trying to remain consistent. But the law changes from one area to the next. But you have sovereign citizens who tell you that the laws don't apply to them, or they can wipe out the mortgage, or that we are corporations and we're entitled to unlimited loans and stuff like that. We're not corporations. Corporations are separate from individuals and vice versa. But again, I don't know what book they got this from. I heard about it once. But I'm sorry, you sovereign citizens, You're misinterpreting the law. Look it up on YouTube. All these people are telling the judge, address me like by a number 1, 2, 3, 9, 6, 7, and the judge says, no, I'm addressing you like this. And the person starts arguing with the judge, who, let's be clear, knows more than you, is saying, I'm addressing you as such, and they start arguing that the law doesn't apply to them, etc. That is absurd. Just based on common sense, it's absurd that the law does not apply to you. So keep that in mind. Sovereign citizens are the perfect example. For fun, look them up on YouTube videos because you're going to be shocked. I mean, but again, I've dealt with them regularly every couple of weeks. I have to talk with one of them where it's this issue of unlimited debt. We don't have to pay back debt, that we are corporations. They're just completely misinterpreting the law. And my favorite is, I just don't have to pay the mortgage because I put last payment there and the bank cashed my check. And again, it's based on the UCC, and the UCC is not law. It is more of a suggestion, is the best way to explain it. And they says, yeah, but the UCC says this and it's negotiable instruments. And again, they are misinterpreting the law. It can't be that simpler. They're just getting a piece of information, running with it and applying it, blanket application, and that's not the way it works. All right. Any questions? Feel free to reach out to me. And I got good news for the paralegal and legal studies students. Today or tomorrow, I'm actually going to post the first video regarding my textbook, because I kept saying I'm going to start creating my own PowerPoints that coincide with the textbook. When you buy them, and you see the link, you can see the link in the description. You can buy directly from Amazon or from Routledge Publishing. But I wanted to create my own separate PowerPoints, not the ones you get with the textbook, just to further elaborate on the issues. So I'm starting to work on that already. I've got 3 PowerPoints all set, and I'm probably going to record a video for today or tomorrow. All right. But likewise, paralegal students, you have any questions, paralegals or paralegal students, if you have any questions regarding these issues, feel free to reach out to me. Okay. So you learned your lesson today on how to be a good client. Be a good client. You better have a good lawyer. Like I said, I've posted those videos as well. If your lawyer, there's no communication, might be time to get another lawyer. All right. Take care, everybody. I'll see you at the next video. Have a good rest of your week.